Okay, so boom, if your name is Constitution Alizé Jones, honey, your enemies are after you and they mean business because between Project 2025 and a Young Thug child, baby, your very existence is going to be a wrap. So Young Thug's defense attorney, Brian Steele, was just thrown into the Fulton County Jail down there on Rice Street, where he was ordered to stay every weekend for the next 20 weekends for not snitching. Mind you, Big T was just convicted of 34 felonies, and all he did was walk out the courtroom and continue talking out the side of his neck. On top of that, he made like 34 million. I digress. Anywho, so Brian had pulled up to the courtroom, right? And he was like, "Hey, Your Honor, I need to holler at you." And the judge was like, "Okay, Brian, what's good?" And Brian was like, "Well, Your Honor, we got an issue because word on the block is that you had a little ex parte meeting with a state witness, and you didn't call me or any other defense attorneys." And the judge was like, "Huh?" And Brian was like, "Bro, if you can hunt, you can hear. You had an ex parte meeting, and you didn't call me or any other defense attorneys, and I got a problem with that. You're not supposed to be doing that." So basically, an ex parte meeting is like a side conference or like a backdoor communication, little chit chat between the judge and parties to the case, but it's not supposed to be about like real issues and substantive stuff that go on inside the trial, right? It's supposed to be like, "Oh, Your Honor, maybe I'm a public defender and, I need to ask the judge, like, hey, I need some extra money so I can get like an expert witness or, another investigation or whatever the case may be." It's not supposed to be about issues in the trial. So the judge was like, "Bruh, who told you what happened?" And Brian was like, "I'm not going to get into all of that." And the judge was like, "No, you need to let me know, like, who told you that this happened." So then Brian was like, "I'm not going to get into all of that. You know why you're at it? Because you were supposed to tell me. Matter of fact, you weren't supposed to be doing that, was you?" So the judge had a little attitude, right? And he was like, "You got 5 minutes to let me know who told you what you think you know." And Brian was like, "You want to stay here for 5 minutes or what you want to do?" So now the reason why this is an issue is because according to page 19 of the Georgia Code of Judicial Conduct, judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of parties or their lawyers concerning a pending proceeding or impending matter, subject to a few exceptions. So the judge kind of confused and he was like, "Okay, well, I hear you, bro, but I need you to tell me who told you my business." So when Big B went forward, the judge was like, "Okay, well, I'm gonna hold you in contempt. Like, you finna go to jail." And Brian was like, "Okay." So basically, holding Brian in contempt of court was basically like the judge gave him an order or told him to do something, and Brian was like, "No, I'm not gonna do that." When the judge tell you to do something, you pretty much supposed to do it. But I guess Big Still was like, "Honey, I've been in the game for a minute. I know who I'm dealing with. I'm not gonna tell you nothing." So the judge was like, "What you mean you're not going to tell me Still?" And Still was like, "Well, it's attorney-client privilege." So attorney-client privilege is an evidentiary privilege, and basically what it means is like whenever, and this is just communication, it only deals with communication, but basically the client could be like, "Hey, bro, I'm going to give you some information." He can talk to his attorney and be like, "Hey, bro, I'm going to give you some information. I need this to stay between me and you. It's not everybody's business. I don't want my business out in the streets." And the attorney, he can't say nothing. He can't testify to it. So the client can refuse to testify about whatever was talked about, but the client can also pretty much be like, "And the attorney can't testify on it either. Keep your mouth shut." Mr. Steele also told the judge, like, who, what, where, when, and however I got the information about y'all little meeting that y'all had, it's attorney work product. Under the law, attorney work product is basically like it ain't nobody business. However the attorney got his information or however he doing what he doing, his theories, whatever he got going on in his mind, however he working this case, it ain't nobody business how I came up with that. I'm keeping it to myself. The exception to that rule is that there is a substantial need for the information, and two, there is no other way to get that information. So the reason why it doesn't seem like it applies in this case is because on the one hand, Judge G, he did not argue that there was substantial need for the information. He just got an attitude when he found out he got caught being a little fugazi. And then on the other hand, it seems like there may be another means of getting that information because the judge said on the record, "I think I kind of know where you probably got this from, but just tell me where you got it from anyway." And Brian still was like, "No." Now, at the end of the day gonna end, but it sounds like it's a little bit of gaslighting going on because it really doesn't matter who told Brian what they told him. The issue is, did y'all have an ex parte meeting in chambers on the low and you didn't tell the defense attorneys? Because under the Sixth Amendment of the Constitution, a defendant has the right to confront an adverse witness. In this case, whether he likes it or not, Mr. Copeland, who is the witness at issue here, he is a witness for the prosecution, which makes him an adverse witness, which means that if y'all was talking to him, Them attorneys should have been present. So then later that night, Brian Steele's lawyer pulled up to court and she was like, "Hey, Your Honor, you know what the problem is?" And the judge was like, "Well, I held your client in criminal contempt because he wouldn't tell me he was out here telling all my business." So then Brian's lawyer was like, "Okay, cool. You said criminal contempt, right?" And he was like, "Yeah." She was like, "Okay, well, cool. Criminal contempt means that he is entitled to due process." Which means you need to run him his charges. You need to let us know what witnesses y'all got, or we need to have a witness list. It's a whole procedure to this. Matter of fact, you really need to be decided if we're gonna have this meeting right here, right now, or right yesterday. And the judge was like, "No, I think the rules is a little different in this case because I'm holding him in direct criminal contempt, which means like we're gonna do this right here, right now." And so he got all the due process he gonna get from me today. Now, mind you, due process is a big deal because it's in the Constitution twice in two different places. It applies to the states under the 14th Amendment, and it applies to the feds under the 5th Amendment. On top of that, you have the right to substantive due process and procedural due process, but I'm not going to get into all of that today. So, anyways, with that being said, Mr. Steele's lawyer was like, "Well, okay, however you want to do that, that's cool. The thing about it is, we are in criminal territory, which means criminal procedure applies. And so, not only do you need to be explaining these charges, but if we're doing direct criminal contempt, well, honey, that means you're a witness. And since you're a witness to this, well, that means that you can't hear this case. You need to go ahead and assign it to somebody else. I'm not saying you got to recuse yourself. What I'm saying is you're not allowed to listen to this. You can't be a witness and a judge on the same case. So you're going to have to assign this to somebody else. Thank you." So the judge is like, "Okay, cool." Anyway, so Mr. Steele, you're going to jail. You're being sentenced to up to 20 weekends in a jail down there on Rice Street for the next 20 weekends. So what you need to do is you need to check in on Friday by 7 p.m. and then they're gonna let you out on Sunday by 7 p.m. And so Mr. Steele was like, "All right, cool, check this out, because I'm not gonna fold. I'm not gonna snitch. I'm not gonna tell you what you want to hear. So either the Court of Appeal is gonna give me a bond, and I'm not gonna have to go to jail. I'm just gonna have to pay this fee, or I'm gonna go to jail. But if I end up having to go to jail to do time, can you just make sure that I'm in the same cell as my client because we still gotta work on our case. And if you don't let me do that, well, you are like interfering with the case, and I don't think you want to do that because you're already in reckless territory." Now, I don't really know the laws when it comes to not snitching. Honestly, I thought it was just street code. But what I am learning is that not snitching will get you more time than trying to steal a country. So Mr. Steele was like, "You know what, Your Honor, that's all cool, whatever you say. I'm not fazed by all that. Anyways, like I said, if I'm going to go to jail, can you just make sure I'm in the same cell as my client because I need to do what I need to do?" And so the judge was like, "Okay, I'll see what I can do, whatever. I'm going to holler at the sheriff and we'll make it happen. You got my word on that." So Mr. Steele is obviously going to appeal this case, and generally an appeal could take forever and a day. However, Georgia has a emergency appeals process, especially for attorneys who have been held in contempt of court. So there may be a ruling on that situation any day now. Honestly, any hour, any second, any minute. So best case scenario, the judges on the appeal court will grant Brian bond, and then again, Brian could just pay the bond, and you'll have to go to jail. Worst case scenario, he's gonna be sitting in jail with Thug on the weekends, trying to help Thug with his case. And I'm sure that anybody who has ever been in jail or been locked up will let you know it ain't nothing worse than fighting your case from the inside, honey. Because you don't necessarily have access to a computer. You may or may not have access to the law library because some jails is different in terms of the rules for that. You may not have access to your case file. You can't make phone calls and all that kind of stuff the way you need to do. Like, it's a whole mess, and I don't wish it on nobody. Like, I would rather squeeze lemon juice in a paper cup than have to fight my case from behind the wall. Now, on the other hand, what I also learned is that if a judge has ex parte communication with a witness during trial, that's a reversible error, which basically means like in the slight chance that Thugger does get convicted of this RICO and this case has to go to appeal, he has to appeal his conviction, a court of appeal is very likely to reverse the conviction on that issue alone. Now, granted, it may take some years, but it's very much an option. So, anyways, that's an update on Young Thug's lawyer having to go to jail. Let me know in the comment section what you think about this. Like, do you think the way the ruling went down was cool? Do you think the judge being sneaky? Like, if you were a juror on this case, how would this make you feel? How did they make this? Please.